Hello, my name is John Tribe and I work at the University of Liverpool and in the Charity Law and Policy Unit. My interests lie in the law of insolvency and how that intersects with charity law. I thought I'd update you on 4 areas that are ongoing in this corona period as part of our Charity Law and Policy Unit series of videos on corona and charities. And those 4 areas then that I'll look at briefly in these 5 minutes are: first, 2 judgments from the High Court on furloughing in the administration procedure. Second, I'll look at Lighttouch administration and this new development that we're seeing in the way in which administration can operate. Third, I'll look at a statutory reform to winding up and statutory demands. And then fourth and finally, I'll examine the area of wrongful trading and how that might be reformed also in forthcoming legislation as a result of recent policy announcements. So our first area then for consideration are the 2 recent judgments from the High Court. One is Mr. Justice Snowden's decision in re Carluccio's, and the other is Mr. Justice Trower's decision in re Debenhams. Both cases relate to the furloughing of employees in administration, and both cases also relate to the technical issue on the adoption of employment contracts in administration. But for us, as people interested in charities, I think the main points that we can take from the 2 judgments are twofold. First, it's the idea that the government's job retention scheme does exist and is permitted within administration as a procedure. So we know that both of the companies, Carluccio's and Debenhams, are for-profit companies, but we also know that administration applies to charitable companies, those companies that have as their objects purposes that are charitable, perhaps a company that's limited by guarantee as opposed to shares. So we know that administration can happen to a charitable company. If it does go into administration, we know then that the JRS, the Job Retention Scheme, also known as furloughing, can apply. There's a technical issue in the cases, as I've said, around adoption and whether or not we think about those employees as having their contracts adopted by the administrator. If the administrator has participated in the furloughing scheme, and of course the answer to that technical issue was yes, adoption has taken place, which has an effect on the administration. But for you as people interested in charities, I think the main point to take from the cases is how keen both judges were, both Mr. Justice Trower and Mr. Justice Snowden, to promote the rescue culture, to help facilitate the rescue of these troubled entities. And what's true, of course, for Debenhams and Carluccio's is hopefully true for charities, that the judges will be keen to help facilitate administrations that are geared towards the rescue of troubled entities, for profit or non-profit entities. And that takes us to our second area of consideration, which is light touch administration. So normally in administration, the administrator, an insolvency practitioner, would take over the day-to-day running of the company, what we call practitioner in possession. But what we're seeing with corona, and particularly with Debenhams, is that a new approach is being used, which we have called light touch administration, and it's where basically the administrator gives the directors of the company, charitable or otherwise, day-to-day control, consents to day-to-day control by the directors, as if things were basically happening in a normal way. And this, of course, is designed to help facilitate the rescue of that entity by taking a light touch approach to its administration by leaving the board in charge, with the objective, hopefully, that the board will remain in charge as the company weathers the storm that's been brought about by Corona, and then hopefully exits the process and gets back onto a normal even keel of liquidity. So for charities, Lighttouch administration is interesting because, just like with for-profit companies, it may enable them to get some protection during Corona, but then transact business pretty much as normal, but under the protection of the administration regime as they progress. This, of course, brings our procedure fairly close to Chapter 11 bankruptcy, which you may have heard about from our American friends. The third area for consideration are the mooted reforms to the statutory demand procedure and the winding up procedure. These are only policy announcements at the moment, so as of the 2nd of May 2020, and we are expecting legislation in due course, and these reforms are supposedly designed to take the pressure off various entities, and mainly the pressure off people who are being pursued by their landlords for failure to pay their rent obligations. So if a landlord issues a statutory demand, of course this could set about the process of ultimately a liquidation. So for charities, this reform is noteworthy because, of course, it means that if the pressure is taken off on, for example, demands for rent, they might have a bit of relief during this period of Corona, much needed relief on their rent obligations, for example. The minutiae of these reforms isn't yet known. The policy announcement was relatively brief, so we'll have to keep our eyes peeled. And of course, we'll update you again with a new video when we know more of the facts. The fourth area of reform was one of the first policy announcements in the area of insolvency, and it again is one that applies to both for-profit and non-profit entities, so charitable companies as well as profit wealth maximising companies. And that's the reforms that have been mooted to Section 214 of the Insolvency Act 1986. And that section regulates what's known as wrongful trading. It's a part objective and part subjective test which basically looks to see how directors have behaved leading up to any insolvency. And what the government have proposed is that those measures, the wrongful trading measures, will be relaxed so that not such a harsh approach will be taken to the way in which directors have acted leading up to insolvency. And this, of course, should provide some peace of mind for directors of charitable companies as well as profit companies, for profit companies. There's been some criticism of this policy, and that's all it is. Again, we don't yet have the legislation. The criticism has basically been that, well, there's still a raft of other directors' duties that need to be adhered to. So this is basically a drop in the ocean of potential liability, and that it really diverts directors away from knowing that they still have other obligations to perform. So for charities, again, one would need to handle this policy proposal with care because we know that there's this backdrop of other directors' duties. So in summary then, we know that these four areas apply to both for-profit and not-for-profit entities. So furloughing and Lighttouch administration are both good things in that they help support a charitable company through these troubled Corona times. And as we've seen, we have judicial pronouncements that are fostering of the rescue culture, so that's all good news for charities. And then similarly, the two statutory reforms that we've looked at are also good news because they take off to some extent the pressure from the boards of directors of charitable companies who are subject to rent demands or other potential statutory demands for indebtedness that charity owes.